Welcome, chatters. I'm still getting used to this microphone, so just bear with me. I realized I could do it in A and B flat, and I feel like I'm in band again. And I have perfect pitch. Easy, Don. Okay, so I'm gonna try not to scare anybody. I have been playing for the last 20 minutes trying to get this down. I don't know what I did. I lost the audio, but I'm going to figure this out. This episode is the SLAPPback. I would stick around, but I've unjustly been blocked. Best of life and luck to you, DOA. Yet here you are, saying hi. It kind of makes it hard to block you. I blocked a lot of people. Just 20 minutes, really. I was trying. Please come back, Para Avita. I don't know. People get blocked all the time. Sometimes I just don't. People annoy me sometimes. Sometimes a harmless thing just is like, fuck you, I'm blocking you. Just let me know. It's really not that big of a deal. Okay. I'm not perfect. And, yeah, it's all right, Paravita. We'll give you a second chance. It's all right. You might have said a bad word. So this episode is Wong versus Dong, the SLAPPback episode. It almost sounds like it's not real. I think they figured it out, Juju. I could be wrong. Yeah, they got it. Everyone. They're figuring it out. Girl or guy, we don't care. We're not judging you here. So I'm working on this. ChatGPT is helping me fuck with the algorithms. I'm doing descriptions. I'm putting nice fancy thumbnails. I'm doing backgrounds, AI for everything, just artificial intelligence. I hopefully it could just start doing things for me too. Maybe I could just get an exoskeleton or whatever it is. And then I have like some Tesla legs or something. They just move me around. I don't have to do anything. But in the meantime, I'm utilizing it to the best I can before they take over and we have to get all Wolverines on this shit. We'll be fighting drones in the woods. The best thing is just go to the national parks and go out into the woods. It's a whole new DOA, allegedly. We'll see. I do like my little avatar. I was like, man, make an anonymous one with the DOA emblem. I was like, oh, that's pretty fucking dope. I don't know if I like the emblem on the bottom. I think I just need a bigger one. Yeah, I'm gonna kill that. I'll make a better one. In fact, yeah, okay, but this is Wong versus Dong, okay? And we're gonna, yeah, it's a gadfly exoskeleton, eco or exco. I'm not sure. I don't care. It's okay. So this is about Wong and Dong. Okay. And it sounds like it's not even true. You can't make this up. The Wong versus the Dong. And we're going to talk about a SLAPPback. So I'm going to learn with you. I'm going to read it. This is going to be the most exciting stream ever. I would love to be trolling people, but I have to learn and I have to not be trolling people all the time. So this is like me having to do shit and figure it out. So allow. That's time. Okay. Now this is going to be the difficult part. How do I? Oh, okay. I don't even have it open anymore. I was fighting this for a hot minute. God damn it. It all closed. Okay, no, it's not. All right. Let's see. I could just open it up in a new drive here. Just give me a minute here. I was working with the sound. Now, eventually I'm going to have this all set up to where I don't have to you don't have to wait. It'll be the most nicely organized. It'll be the best ever. But I suck at everything I start, and I just didn't have the capacity to be doing this. But here we are. I'm finally figuring it all out, one little thing at a time. All right, we're in felony folder, La Poubelle, Dumer. Oh, I didn't. Oh, Wong versus Dong. Okay, Wong versus Dong. New tab, add tab to new group, duplicate, move tab, pin tab, mute tab, refresh, add tab to new group. No, damn it. What do I gotta do? I think I gotta. Okay, let me see if I could share the screen. If not, I'll just read it. Okay, pretend share screen. Oh, I need the Wong versus Dong. Master timeline, Google Docs. Where the fuck is that at? Oh, there it is. My mic doesn't work. I was asking questions. StreamYard Studio, no. Master timeline. Oh, because it's telling me we're looking at the master timeline. That makes no sense. Okay, I had to open up in Firefox. So maybe I'll just open it here. Okay, dismiss. All right, I'm going to figure this out. I'm a little slow. Wong versus Dong. Wong versus Dong. How do I get a Wong versus Dong? Like that's you couldn't ask for anything better, really. I'm telling you. Okay, Wong versus that entire screen. Fine, fuck it. Just do the entire screen. I don't give a fuck. StreamYard Studio, master time. Select window or screen. Everything's always just so fucking complicated. God damn it. Master timeline. Studio. No, that looks confusing. I guess it could work. Not now. Your browser has blocked your screen to address your address bar to allow access. Okay. You fucking motherfucker. Turn your VPN. Manage account. You're so fucking stupid. Firefox is fucking weird. New tab. No, okay. I'm just gonna read it. Fuck it. Related to long dong, duck dong. Okay. Well, first I'm gonna read. You don't need to fucking see the text. You really just don't. Okay. Yeah. You don't have to see the text. And let's go to. All right. So I was learning things today. Oh, this is why. This is all the way down here. Okay. So, Code of Civil Procedure, Section 4. We're going to start with the SLAPPback, and then we're going to talk about Wong versus Dong. SLAPPback. Everyone knows what the anti-SLAPP is, or maybe you don't know what the anti-SLAPP is. I don't know, chat. Do you guys know about anti-SLAPP? Maybe. I don't know if you guys pay attention. Sometimes I wonder about you. Sometimes I wonder about myself. I totally lost you anyways. It doesn't fucking matter. I want to interact with chat, though, because they're important to me. 16 candles. That's what I was thinking. That's all I could think of was 16 candles. Oh, dong. So, the great God gave us Wong and Dong. Okay. So, Dorothy knows about anti-SLAPP, allegedly, but they didn't get paid, so what was it really? I don't know. Matt's probably sucking on some thumbs. If you know, you know. All right, so anti-SLAPP. There is a whole nother thing called the SLAPPback. And I was like, this can't be real. Like, I thought ChatGPT was lying to me, but ChatGPT knows everything. So the SLAPPback. 425.18 Code of Civil Procedure. The legislative finds and declares that a SLAPPback is distinguishable in character and origin from the ordinary malicious prosecution action. The legislate further finds and declares that a SLAPPback cause of action should be treated differently, as provided in this section, from the ordinary malicious prosecution action, because a SLAPPback is consistent with the legislative's intent to protect the valid exercise of the constitutional rights of free speech and petition by its deterrent effect on SLAPP, strategic lawsuit against public participation litigation, and by its restoration of public confidence in Participatory democracy. For the purpose of this section, the following terms have the following meanings. SLAPPback means any cause of action for malicious prosecution or abusive process arising from the filing or maintenance of a prior cause of action that has been dismissed pursuant to a special motion to strike under Section 425.16. Special motion to strike means a motion made pursuant to Section 425.16. The provisions of subsection C, F, G, and I of Section 425.16 and paragraph 13 of subdivision A of Section 904.1 shall not apply to special motion to strike a SLAPPback. Special motion to strike a SLAPPback shall be filed with any of the following periods of time as follows: within 120 days of the service of the complaint, at the court's discretion within 6 months of the service of the complaint, at the court's discretion at any time later in extraordinary cases due to no fault of the defendant upon writings finding on the court standing. Okay. So it'll be filed with any of the following period of time as follows. So I might not be able to actually do this. I might be out of time. Within 120 days of the service of the complaint, at the court's discretion within 6 months of the service of the complaint, at the court's discretion at any later time in extraordinary cases due to no fault of the defendant upon written findings of the court stating the extraordinary cause and circumstances. The motion shall be scheduled by a clerk of the court for a hearing no more than 30 days after the service of the motion unless the docket conditions of the court require later hearing. A party opposing a special motion to strike a SLAPPback may file an ex parte application for a continuance to obtain necessary discovery. If a court finds that a special motion to strike a SLAPPback is frivolous or solely intended to cause unnecessary delay, the court may award costs and reasonable attorney fees. Upon entry of an order denying a special motion to strike a SLAPPback claim or granting the special motion to strike as to some but less than all causes of action alleged in a complaint containing a SLAPPback claim, entry of an order denying a special motion to strike a SLAPPback claim. Oh, wait, hold on. Is it about? Hold on. See, this shit, all the rules fucking. Special motion to strike a SLAPPback shall be filed with any of the. Okay, this is for the. Oh, okay, cool. Ooh, I'm still good, I think. All right, let's talk to ChatGPT real quick. I gotta ask ChatGPT, man. This motherfucker leading me in the wrong goddamn path, make me look fucking dumb as fuck. Like, oh my god, DOA's using this shit. You're such an idiot. I can't believe he's using ChatGPT. There's cars driving themselves, robots fucking feeding food, weirdos yelling at the robots. Like, they got all this shit, man. And then DOA uses a little ChatGPT, and he's the most evil person ever. All right. Okay, so I just uploaded Wong versus Dong in the other case. And so, what is the statute of limitations for filing a malicious prosecution case and using an SLAPPback thing? SLAPPback thing. I can't even think. Wong versus Dong. Yes, in California, the key distinction is the SLAPPback is not a separate tort with its own limitations period. It's a statutory classification procedure that can apply to a malicious prosecution or abuse of power action. Basic deadline, 2 years. California malicious prosecution claims are generally governed by the 2-year statute of limitations Code of Civil Procedure 335.1. The California Supreme Court confirmed this in 2025 in Escamilla versus Vanucci. The important question is when those 2 years begin running. So this is important. Hey, Witchshare. Hey, girl, how you doing? I just want you to know that you bought me this soundboard, I think like fucking 2 years ago, and I like gotten rid of a bunch of shit, but I was like, I'm not getting rid of this fucking soundboard. I'm going to figure it the fuck out. In my brain, I couldn't process how to fucking get this thing working. And I fucking got it working. Here, I'm going to play my little song. Da-da-da-da-da. Social activism, motherfucker. Uh, 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 Social activism, motherfucker. Social activism. I don't even know it. I like I got Dodge in here. I love that. And then we could, what's up, Kirby? What's up, girl? I like the little Robin thing. This is trigger warning. Okay, so you couldn't hear the song, huh? Damn. Okay, well, I haven't figured it out yet. There's directions. I did read some of the directions. I did music. I was having trouble, so I'm still working on it. And like, it gets all reverby when I get away from the mic, but then I'm close. It doesn't. So I'm trying to figure this out. All right. Well, last time I had to hit music only, music not. So I got a lot to work on here. Okay. So let's get back to the shit. I just had to give a shout out to Woodshare. Thank you for getting me that. I think it was like 2 years ago. Okay, well, that's all you have to hear. I thought you guys were hearing my song. I thought this was like the best podcast ever, but it's the worst podcast ever. We'll just talk about Wong versus Dong. SLAPPback versus Superior Court explains that a malicious prosecution cause of action generally occurs upon entry of the favorable judgment dismissal in the underlying trial of court action. If an appeal is actually filed, the limitations period is told during the appellate process and begins running again after the process concludes. Okay. Where the SLAPPback comes in, CCP 425.18 defines a SLAPPback as a malicious prosecution or abusive process cause of action arising from a prior cause of action that was dismissed pursuant to an anti-SLAPP motion. And the new 2025 Wong versus Dong decision is especially interesting for your situation because the court held that the prior plaintiff's voluntary dismissal while the anti-SLAPP motion was pending could still produce a SLAPPback, where the trial court subsequently determined for purposes of attorney fees that the anti-SLAPP motion would have been granted. The court expressly said all the statutory elements of a SLAPPback were present. So you don't file a SLAPPback motion, you would ordinarily file the malicious prosecution lawsuit, which I have against Francois Coster. And if it satisfies 425.18 subsection B subsection 1, it receives the special SLAPPback treatment. There's another major procedural advantage. If the defendant then anti-slaps your SLAPPback, 425.18 changes the normal anti-SLAPP rules. Soakup explains that the legislative internet intentionally stacked the procedural deck in favor of the SLAPPback plaintiff. Among other things, discovery treatment is more favorable. Unrelated gossip: Palm Tree might have gotten arrested tonight exploring burned out school. Ended when cops showed up. Live is gone. Well, God, influencers of Hollywood. Ugh, God. I think has Nora done like 3 streams about Aaron breaking his probation terms yet, or what? The defendant loses anti-SLAPP motion and against there's an all right in our life. Okay, so I have a meet and confer with the attorney from La Poubelle, the La Poubelle lawsuit. The attorney is representing both Francois Coster and La Poubelle. Phonies, photo guy. the photo guy, I can't, like, I see photo guys thing come in the email, I stop everything and I read it. I'm, like, so interested in what he has to say. He was talking about the rack of some chick. He holds no bar. He's probably gonna be canceled, but he can't be canceled because he doesn't give a fuck. All right, so they're trying to look for him. He had some type of. They were trying. Yeah, he doesn't care. It's kind of funny. I was thinking about. Yeah, he's got me thinking. I love it. I love what he's. Oh, okay. All right. Let me go to Wong versus Dong. Certified for publication in the Court of Appeals of the California First Appellate Division 5. Tis King Wong, plaintiff and respondents, versus Yidong. Yidong? I'm not good with these words, man. Yidong. Defendant and applicants. God damn it. I just realized we're going to do this again tonight because I think I forgot again. Yep, I did. All right, I'll do this with you guys. This is my attention span. Not getting anywhere.
El pelo rubio.
El pelo rubio. The blonde hair. Yeah, pelo.
Ellas son mis sobrinas.
They are my sobrinos, nieces, sobrinas. Yeah, that's it. Hair, pelo,
Pelo.
pelo. Niece, sobrina,
Sobrina.
sobrina.
¿Quiénes son sus amigos?
¿Quiénes son sus amigos? Where is with the amigos? Y son sus sobrinos. ¿Y quiénes sus sobrinos?
¿Quiénes?
¿Quiénes? Oh. ¿Quiénes son sus amigos? ¿Y quiénes son sus sobrinos? Okay, got it. Ba-bing! Who? ¿Quiénes?
¿Quiénes? ¿Quiénes son las mujeres rubias?
¿Quiénes son las mujeres rubias? The rubias. Who are the blonde women? Mujer, like the J's just kill me, man.
Ah, ¿tus sobrinos tienen el pelo negro?
Ah. Tus sobrinos, your nephews, sobrinos are, Tianan, have, your nephews have the el pelo negro, black hair. Your nephews have black hair. Got it. Boom.
Tienen el pelo largo.
Tienen el pelo largo. Tiana, do they have pelo largo? Pelo largo, long hair. Pelo largo, largo's long. Yep. Okay.
Sí, ahora tienen el pelo largo.
Sí, ahora tienen el pelo largo.
¿Quiénes son los hombres con sombrero?
¿Quiénes son los hombres con sombrero? Who are the men wearing hats?
Ah, tu sobrina es pequeña.
Ah, tus Sabrina.
Sobrín es pequeña.
Oh, your niece is little.
Mi sobrina es la chica morena y su novio es este chico bajo.
Oh, wait, what?
Mi sobrina es la chica morena y su novio es este chico bajo.
Chico bajo. ¿Y quiénes son los chicos altos? No, ¿quiénes no sé si, not sure. ¿Y quiénes son los chicos altos? Got it. And who are the tall boys?
Tu sobrina pinta, ¿verdad?
Two. Sabrina.
Sobrina,
Pinta.
pinta,
Verdad.
¿verdad? Tu sobrina, pinta, ¿verdad?
See. Your niece's pants. Pinta. Pinta. Shoe is zapato.
Zapato.
Cousin is primo.
Primo.
Who is quienes?
¿Quiénes?
Tall is alto. Niece is sobrina. I like the
Sobrina.
word together. ¿Quién es la chica con el pelo largo?
Largo.
Who is the girl with the long hair? Who's the girl with the long hair? Yep. Boom. Another. Okay. All right. Lettuce. Lechuga.
Lechuga.
Hair is pelo.
Pelo.
Oil is aceite. Aceite.
Aceite.
Aceite. Cousin is primo.
Primo.
Another is otro.
Otro.
Perfect. Perfect lesson. Goddamn right, bitches. Boom. Sorry for wasting 5 minutes of your life. Wong versus Dong. Wong versus Dong. Okay. Alameda County Superior Court, 23 CV. So this case was started in 2023. This is an interlocutory appeal for an order denying a motion to strike or dismiss a malicious prosecution action. We lack jurisdiction to review the order under the anti-SLAPP statute. Because this case is a SLAPPback, the order is reviewable only by petition for a preemptory writ. The remainder of the appeal, over which we do have jurisdiction, is without merit. Background. Enacted in 1992, the anti-SLAPP statute is now well established in California law. 425.16 is designed to weed out lawsuits brought primarily to chill free speech or petitioners' rights, suits the legislative has deemed an abuse of the judicial process, such as 1. Designated statutory references are the Code of Civil Procedures. A lawsuit is called a strategic lawsuit against public participation, or SLAPP suit. Section 425.16 authorizes a court to strike a claim that arises from an act in furtherance of the defendant's right of free speech or petition. Protected rights include the right to file a civil lawsuit. Okay, in the earlier lawsuit, Wong and, King Wong and Hichi Wong, collectively the Wongs, sued Yi Dong over unpaid rent. Dong then filed a cross complaint alleging that the Wong's lawsuit constituted abuses of process, intentionally caused him emotional distress, and violated the unfair competition law. In response, the Wongs filed a motion to strike the cross complaint under the anti-SLAPP statute. While the motion was pending, Dong voluntarily dismissed his cross complaint. Despite the dismissal, the trial court ruled on the merits of the Wong's anti-SLAPP motion for purposes of determining their entitlement to attorney fees. So the anti-SLAPP is kind of interesting because there's like two prongs to it, kind of. There's two prongs to the decision making of it, but there's like the trial court ruled on the merits of the Wong's anti-SLAPP purposes for determining the entitlement to attorney fees. The court held that, what's up, Adrian? The court held that the cross complaint arose from activity protected by the anti-SLAPP statute, and that Dong failed to demonstrate a probability of a success on the merits of his complaint. As a result, the court concluded that the anti-SLAPP motion would have been granted and had the case not been dismissed. Which brings us to this case. The Wongs have now filed a malicious prosecution action for damages caused by Dong's cross complaint here. Hold on. Hold on. This is going to be fun with this. Hold on. Let's get a little soundbite here. Now that I'm like, I got the soundboard and shit, man. I think this is necessary for today. Just for fun. Dong from the movie. What is it? Babysitter's Club? Is it Babysitter's Club? No, it's not the Babysitter's Club. It's what's up, Curbs? Adrian. What movie's the Dong in where he falls out of the tree? Dong. 16 Candles. Good. Okay. 16 Candles. Dong. Let's see here. Oh, I can't. I didn't know how to do the song. Okay, I can't do it because I forgot. I can't figure it out. So no, I can't do it. I'm a loser. All right. Damn, I could have figured out the thing. Okay, which brings us to this case. The Wongs have, I can't. You can't hear it because I didn't know how to fucking. It's not happening. Not this time. It would be really cool to have the dong. Okay, the Wongs have now filed a malicious prosecution action for damages caused by Dong's cross complaint. They allege that Dong and his attorneys, Chang Chan Zhu, Merca Law Group, and Vincent Law PC collectively, Dong, brought a cross complaint for a malicious purpose, that it lacked probable cause and that it caused them damages. Dong responded by filing his own motion to strike under Code of Civil Procedure, Section 425.16. Arguing that the Wong's malicious prosecution action is itself a SLAPP. Okay, interesting. Dong responded by filing his own motion to strike under Civil Code of Procedure, Section 425.16, arguing that the Wong's malicious prosecution action itself is a SLAPP. Oh, interesting. So they're saying that his anti-SLAPP suit was filed against him, against the Wongs, Dong filed the anti-SLAPP suit against Wong, and then Wong is following the SLAPPback suit, and Dong is alleging that itself is a SLAPP. Alternatively, Dong sought dismissal under Civil Code of Procedure Section 1714, which establishes procedural prerequisites for conspiracy causes of actions against attorneys. The trial court denied both requests. Dong filed the instant interlocutory appeal from this order, citing Codes of Civil Procedure Section 426.16. The threshold question is whether we have jurisdiction over Dong's appeal from the denial of his anti-SLAPP motion. Although the Wongs do not challenge our appellate jurisdiction, we are obligated to consider the question sua sponte. See West versus Arendt Fox, LLP. We dismiss this portion of Dong's appeal for lack of jurisdiction. Ordinarily, under the one final judgment rule, an order that does not resolve all the claims in the case is not appealable until the conclusion of the case. This is the bedrock principle of appellate law. You need a final order, basically. It seeks to avoid the inefficiency and experience caused by piecemeal appeals. Courts will not recognize exceptions to this rule unless they are clearly mandated. One such exception is an order granting or denying an anti-SLAPP motion to strike. Oh, interesting. Authorizing appeal from an order granting or denying a motion to strike under Section 425.16. The legislative determined that the right to an immediate appeal is necessary to protect First Amendment interests. I kind of love all this, like, talk about First Amendment. You know, this makes it worth it. Like, it's not just boring law. This is about our fucking freedom of speech. And if you guys aren't familiar, Aaron filed an anti-SLAPP. And contrary to a bunch of fake ass bitches who don't know anything about court and who want to judge all the time, there has not been a ruling done in that court yet. Okay. Damn, you guys looked really dumb. You know, I could either like ignore the haters or just kind of poke fun at it. Like, I don't know. Like, do you give them any breath? Do you not give them any breath? Will they go away? They sometimes go away. They don't. But I could. Oh, damn! Thanks for the $50, yo. I appreciate that. Thank you. You're so kind. Oh, thank you. I'm gonna have to have some boudin balls now in your honor. All right. Well, that's perked me up a little bit. Legislative denied that they're all right. So Aaron filed the anti-SLAPP, and Aaron's not going to win the anti-SLAPP. I feel pretty damn confident. Like his anti-SLAPP was without merit. Oh, like give me another year of this, man. I'm gonna be dangerous as fuck. I'm actually enjoying it. Like I told the lawyer, so I'll be in court tomorrow. He is also going to get people to pay to go get signatures for the Garden Street vacation petition, $10 per signature. Thought he didn't have money for a lawyer. Well, he doesn't have to pay a lawyer. He could just pay out the offer and just take the copyright strike and everything's good. But we want to do lawfare, so we're going to go to war on the law thing. It's not really war. It's just, you know, how smart can you? I don't know. I kind of really enjoy it. So I told the lawyer, I was like, I wrote him an email. We were going back and forth in the emails, and I told him I was like, oh yeah, okay. I was trying to like put together a thing for him, and I was like, yeah, I'm gonna be talking about a SLAPPback and Wong versus Dong, and I was like, this is gonna be fun to argue Wong versus Dong, and so I'll catch you tomorrow. I'm gonna try to catch him after the AM court session, and I actually got to find out. I think I'm in Stanley Mosque tomorrow. Mosque. So I got to wake up in 8 hours from right now. So I'm looking forward to it. So I'm going to do a little content besides my court case stuff. So yeah, back to the case here. We're back to Wong versus Dong. But this exception, I'm really enjoying, like, I told Save the Garden is paying $10 for canvassers. They are raising money. Yes, that's correct, Juju. They're raising $10 for. Yes. He is raising money to help stop them, I believe is what was going on. No. You have court today? No. Today's 11 p.m. We're still at night. So tomorrow, no, I don't have court. I'm going to follow a court case. And then on the 17th, I'm going to be there for the Patrick Perry case. And then what day is that? The 26th, I have my first civil suit case appearance. It's a case management appearance at Stanley Mosque for this case, for the La Poubelle case. So we're going back and forth. Yeah, he said he was going to do the same thing or something. Yeah. I didn't watch it. I thought I saw some of it. All right. Well, I'm glad you're in here, Paravita. Thank you for sticking around. All right. It's not the most exciting stream, but it's going to get exciting. We're like the bricks and minifigs times 10. They just don't know it yet. We've been working on, I worked on the lawsuit for the San Luis Obispo, and right now it's 110 pages long. It got really long, and that's okay. There's a couple new people that are going to be sued in that case, and so it's actually been, I was like not knowing how I was going to do all this. Actually, let's jump over there for a minute. No, I should finish this. I'm gonna go over there and talk about that. I'm gonna finish this Wong versus Dong because I have attention ADD. I did see that he came and looked at your channel. Oh, Holly Lewis, nice. I saw that he had raised. Sheldon was the person with the bricks and minifigs. He raised $100,000 for his court case. I googled it. His name. I didn't know who he was. Okay. All right. I feel like Reese just engaging with chat. You psychopaths. Okay, but this exception does not apply if a party moves to strike a so-called SLAPPback. When the target of SLAPP succeeds with a motion to strike, the target will sometimes file a malicious. When the target of a SLAPP succeeds with a motion to strike, the target will sometimes file a malicious prosecution action for damages against the SLAPP filer, as a Wong's purportedly did here. See Sukup versus law offices. He was at American Fork. Okay. Was he the one who was Sheldon the one who swiped the phone and locked it? And then they said he was trying to destroy evidence. Is that Sheldon? This is called a SLAPPback. I love this word, SLAPPback. And the Wong, I just love all the words here. The SLAPP filer, in turn, sometimes tries to turn the tables by filing their own motion to strike under the anti-SLAPP statute, as Dong did here. Okay, cool. I got it. See, I pay attention, man. This the details that really matter. The difference is our chat has intelligent things to actually say to it. Well, we don't we can make fun of people and make fun of like stupidity, like Henry's like fundraiser that raised like $25 and him just lying through his ass. Like that shit's fun, right? But we don't have to make threats. We don't have to like body shame everybody. I mean, we could talk about his curly hair once in a while. All right, I'm staying on topic here, though, fuckers. The SLAPP filer, in turn, sometimes tries to turn the tables by filing their own motion to strike under the anti-SLAPP statute, as Dong did here. However, in the situation, the legislative has foreclosed an interlocutory appeal from the trial court's rulings. Appellate review may only be attained through a preemptory writ filed within 20 days of service of the denial order. Section 425.18 explains that SLAPPbacks are treated differently because a SLAPPback is consistent with the legislative's intent to protect the valid exercise of the constitutional rights of free speech in the petition by its deterrent effect on SLAPP litigation and by its restoration of public confidence in participatory democracy. Accordingly, Section 425.18 stacks the procedural deck in favor of the SLAPPback plaintiff confronted with a special motion to strike. The legislative adopted an expedited writ process rather than an interlocutory appeal to limit the delay and expense the plaintiff might otherwise incur while the case is on appeal. Extraordinary writs are an amazing thing, people. But some don't know about it. It's really important stuff. Whether we have jurisdiction over Dong's appeal thus turns on whether the Wong's malicious prosecution does, in fact, meet the criteria of a SLAPPback. Section 425.18 subdivision. Okay, here we're getting into the meat of this, man. Subsection 425.18 subdivision B/1 defines a SLAPPback as any cause of action for malicious prosecution or abusive process arising from the filing or maintenance of a prior cause of action that has been dismissed pursuant to a special motion to strike under section 425.16. See Hutton versus Hafe. The Wong's case appears to meet this definition. It is a malicious prosecution action that rose from Dong's cross complaint in the prior action, which was dismissed after the Wongs filed a motion to strike under section 425.16. Dong argues, however, that his cross complaint was not dismissed pursuant to the motion to strike because he voluntarily dismissed it while the motion was pending. We are not persuaded, and neither am I, okay? We broadly construe that SLAPPback statute looking to its text and its legislative intent. Sukup, Supra 39 Cal 4th District at page 279. The text of the statute specifies merely that the dismissal occur pursuant to a special motion to strike. 425.18, subdivision B, subsection 1, not a court's order or such a motion. Indeed, the legislative made precisely this distinction in section 425.16, subsection I, which authorizes interlocutory appeals from an order granting or denying a special motion to strike. Baby got back? Baby got back. 425.16, subdivision D. I do have this. They just like my butt. What can I say? It's nice and juicy. Juicy. Big, fat, juicy booty. Gonna bend over and do my doodad. Big, fat, juicy booty. Gonna bend over and do my doodad.
I do
Big,
hope.
fat, juicy booty. Gonna bend over and do my doodad.
I do
Just like my
hope.
butt. What can I say? It's nice and juicy. Juicy.
Have every right
Big,
to film
fat,
in a public
juicy booty.
space, bitch.
Gonna bend over and do my doodad.
Fuck you.
Big, fat,
Take your hood right at
booty.
home.
Gonna bend over and do. All right, sorry, just playing. Okay, I do have sound in the song board. It's not on my board, but in the StreamYard. An order denying or granting a special motion to strike is SLAPPback. Moreover, there is no mystery about how the trial court would have ruled on the merits of the Wong's anti-SLAPP motion because it did rule on its merits for purposes of awarding attorney fees, concluding that it would have granted the motion. By voluntarily dismissing the cross complaint, Dong simply saved the trial court the trouble. All the statutory elements of a SLAPPback are present here. Our Constitution best effectuates the legislative's purposes in enacting the SLAPPback statute to favor SLAPPback plaintiffs who are engaging in constitutionally protected activity. Oh, talk to me dirty. And limit abuse of the judicial process by SLAPP filers. Abuse of. Wait a minute. I filed the SLAPP though. I won the SLAPP though. I'm thinking, oh my gosh, this is not okay. Let me go back to this. For anti-SLAPP, I filed the anti-SLAPP though. Okay. See, this is if you feed garbage in, you get garbage out. Hold on. I might be wrong here. Let's see here. Like, I'm processing this in my head, and I was like, wait a minute. Fuck. I sound like an idiot now. What if I filed the anti-SLAPP suit? Hold on. What if I filed the anti-SLAPP suit and I won? Does that apply to my malicious prosecution claim? Does that apply to my malicious prosecution claim against Cosser because she lost the. I'm like processing. I'm sober as fuck. Okay, because she lost the SLAPP. Because she lost the SLAPP and had to. I'm just pay attorney. See, this is me doubting myself. Am I an idiot? It's okay. You got nothing ventured, nothing gained. Yes, potentially, and your facts are considerably stronger than merely saying cost or loss or restraining order case. Must prove from. Okay. Yes. Okay. Koster filed a civil harassment proceeding against you, 24 STR0, STRO 01357. You filed a special motion to strike. Laws are fucking telling me about it. I'm not even smoking weed, man. Like, I'm drug motherfucking free. I'm not drinking booze, just stuffing my face with food, but that's it. Like, maybe I'm high on food, but fuck, man. You filed a motion strike under CCP 425.16. On June 25th, 2024, Judge Richard Bloom granted your anti-SLAPP motion. The court simultaneously advanced the restraining order hearing and took it off the calendar. The court found Koster's opposition tremendously flawed. Oh, God, that makes it sound so good. And offering little to no evidentiary. We're just lost souls swimming in a fishbowl year after year. Space might be the final frontier, but it's made in a Hollywood basement. Okay. The court found Koster's opposition tremendously flawed and offering little to no evidentiary value because purported factual material was outside sworn declarations and numerous exhibits were unauthenticated. On November 6th, the court awarded $120,000 and $487.94 in attorney fees and costs, collectively in your and Good's case. I go by the other defendant. I'm gonna get the last laugh. I'm gonna be that dirty like cigarette laugh. I don't smoke, thank God. Nasty habit. No offense to you smokers. You guys are okay. The proposed judgment says that June 25th anti-SLAPP motions were granted. The November 6th fee motions were granted, and judgment was to be entered in favor of you and Good. Why that matters for a SLAPPback. This is much closer to the statutory definition of than Wong versus Dong was. CCP 425.18 defines a SLAPPback as a malicious prosecution or abusive process claim arising from a prior cause of action that was dismissed pursuant to a special motion to strike under 425.16. And Wong, the underlying cross-complaint had actually been voluntarily dismissed before the anti-SLAPP motion was formally granted. Nevertheless, the trial court subsequently determined in the fee proceeding that the anti-SLAPP motion would have been granted. Okay, the Court of Appeal held the resulting malicious prosecution was a SLAPPback. Your record appears cleaner on this particular issue. Your anti-SLAPP motion actually was granted. So assuming the judgment finality record does not contain something material different than what we've seen, I think there's a strong basis to characterize your malicious prosecution claim against Koster as a 425.18 SLAPPback. But it does not automatically prove malicious prosecution. This is a critical distinction. You still need the traditional elements: favorable determination and lack of probable cause, and malice. Oh, we love malice, don't we? Oh, yes. With malice, we're talking about malice. Malice is not a crime. Who the fuck was saying that malice was a crime? I can't even remember. There's a lot of idiots out there. Who said that? I can't remember. DOA. Oh, was it Lindsay's dumbass? Oh, he's acting maliciously. It's a crime. I beat my mom because I was on Xannies. I was on the bars, bro. I don't know why people want to be all fucked up like that, like a zombie, man. I don't understand that shit, man. I want to be up. Get me going. Doot, 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 doot. I ain't gonna do fucking lines off of a toilet, fucking off of the seat of a toilet. That's disgusting, Tommy. You're disgusting. You're a rapist. Bubble down on my dick, bitch. Oh gosh, I love this microphone. It's so fun. It's like I could hear like everything is so different with the microphone. Bubble down on this. Do you know that the bubble down was probably a commercial coming through the chat? Someone said that like it was probably just like the local advertisement because it's bubble down is a thing. I guess they can't. I don't know. Would they have commercials? Yeah, bubble down. I love it. I don't know. That doesn't make sense because I don't think I've ever seen a commercial on a fucking in chat. But Yes, Renee, this is what we're here for. Holly Lewis. Yeah. Okay. So, all right. So I was questioning all this shit because that's good to do. Like, I'm not like it is. I'm not understanding because Dong filed the anti-SLAPP and Wong filed it back. So it was throwing me off because Dong was the one who filed that anti-SLAPP, not Wong. But Dong said that Wong filed the anti-SLAPP, so it was confusing. So Wong, Wong, like SLAPPback, SLAPP, anti-SLAPP, like it's confusing as fuck. And so I just have to come back and read it, and like I'm not that smart, y'all. It takes a little time to upload, right? But I'm gonna do my best. Fake it till you make it, baby. I eventually get it. And so I think the biggest thing that the biggest hurdle I have for my malicious process, because so I sued Francois for 2 different causes of action. The first cause of action is it's like ping pong with Dong and Wong. Exactly. Dong Wong, Wong Dong, ping pong. I haven't played ping pong in a long time. So I have 2 causes of action, a negligent security and a malicious prosecution. And so the negligent security is for being attacked in front of the building. And I just kind of found out some information today. I was doing a little, me and ChatGPT, my counsel were doing a little research. And I was thinking about the egress and the ingress and egress out of La Poubelle. Well, and I was like, okay, there's one door. Okay. And there's one door coming out. All right. And why does that matter? It matters when there's over 50 people in the restaurant. Okay. If there's over 50 people in a restaurant, you have to have 2 exits. Okay. So technically, there are 2 exits at La Poubelle, but one of the exits comes together. Well, if Dorothy won the motion for lawyer fees, what would be what about me, Juju? What about me? Like, think about it. The anti-SLAPP's only for the fucking lawyers. The bar, all these motherfuckers, right? It's only the lawyers getting the money. What about the person that fucking had his constitutional rights infringed on? And so the SLAPPback is for, well, okay, so there's 2 things. Okay, I'll explain it because I think I understand it. I'm glad you asked that question. Good question. Thank you. And thank you. All right, I lost it. No, I have it. Don't lose it, Scott. Don't lose it. A malicious prosecution claim can only be done when you've actually been to trial. Okay. You have to go you actually have to be in the trial or the court, I believe. And so normally it would be a malicious prosecution would be because you have to actually go through the actual trial, the court thing. And what makes a SLAPPback interesting is that you don't have to go through it. And so, yes, so I do get, yes, I could be compensated for my time and for my injury of being falsely accused. And so the elements of which I think I'm getting into here is 1, it has to be ended without a conviction. It has to have ended without, so you have to be the prevailing party. And for the SLAPPback, you have to have, there has to be no probable cause, and it has to be malicious, favorable termination. So I think I'm about to get into it if I ever get done reading this. Recognizing that the Wong's action is a SLAPPback, notwithstanding Dong's voluntary dismissal of the cross complaint, comports with those purposes by minimizing the delay and cost to the SLAPPback plaintiff. A SLAPP filer cannot avoid an attorney fee award by voluntarily dismissing the SLAPP complaint, while a motion to strike is pending because it would undermine the deterrent purposes of the anti-SLAPP statute. It is also consistent with the one final judgment rule, which requires exceptions to be clearly mandated. So there has to be a final judgment. What did I just deal with that for? I just had the final judgment thing go on in something else. Can't remember what it is. I'll think about it in a second. Finally, we reject Dong's argument that even if the action would otherwise qualify as a SLAPPback, this case is not a SLAPPback because two of the defendants, Zhu and Vincent Law, were not parties to the earlier litigation. Although they were Dong's counsel in the case, the legislative defined a SLAPPback action without reference to the parties in the earlier action. Arndt Fox, Supra 237. Yeah, well, the Wong versus Dong, he voluntarily did it, and my judge did it, and I'll read a little bit of why it's important for me. Broadly defines a SLAPPback to include any cause of action for malicious prosecution or abusive process arising from the filing or maintenance of a prior cause of action that has been dismissed pursuant to a special motion to strike. In sum, Dong had no right to an interlocutory appeal from the denial of his anti-SLAPP motion. He was required to file a writ of petition within 20 days of being served with notice of the trial's court order, which he did not do. We lack jurisdiction over that part of the appeal. Separate from this challenge to the denial of the anti-SLAPP motion, Dong contends that the trial court erred in denying his motion pursuant to Civil Code Section 1714.10. We disagree. Civil Code Section 1714.10, Subdivision A, establishes a pre-filing requirement for a cause of actions against an attorney for a civil conspiracy with his or her client arising from an attempt to contest or compromise a claim or dispute, and which is based upon attorney's representation of the client. Before filing such a claim, the party must establish a reasonable probability of prevailing and obtain a court order allowing the claim. The special procedure reflects a substantive rule of law that a cause of action for conspiracy is not viable where the alleged conspirator did not personally have a duty to the plaintiff, but instead was serving only an agent or employee of someone who did have a duty. The failure to obtain the I'm skipping pre-approval from the court in a defense to a conspiracy cause of action against a requisitive. I wonder if there are any bongs too. I bet you there'd be a bong. Dong argues that the Wong's malicious prosecution action would be dismissed because it alleged the existence of a conspiracy between Dong and his attorneys. Well, I know how it's spelled, Holly. I could see the fucking word. I can't say it. Requisite. I could hear it. I can't say it. You got to put it out in syllables for my dumb ass. RQSTE. It sounds like dong. Requisite. This is part of my speech impairment, okay? Thank God for the ADA. Dong argues that the Wong's malicious prosecution action must be dismissed because it alleged the existence of a conspiracy between Dong and his attorneys, and the Wongs never obtained pre-filing approval. But Civil Code Section 1714.10 does not apply when a malicious prosecution action alleges that the attorneys themselves acted maliciously in bringing a meritless lawsuit. And the trial court's orders denying relief under Civil Code Section 1714.110 is an appealable order. It seeks to hold attorneys independently liable for their own actions or omissions. Here, the Wong's malicious prosecution complaint alleged that each of the defendants, including Zhu and Vincent Law, filed a cross-action without probable cause and continued to maintain the action without probable cause, acting maliciously. The complaint thus sought to hold Zhu and Vincent Law liable for their own actions independent of any liability on Dong's part. And Civil Code Section 17.4 is inapplicable. It is true that the Wong's complaint also included an allegation that each defendant conspired with each other to commit the wrongful acts and omissions detailed in the complaint, but the complaint pleads only a single cause of action, malicious prosecution, but does not premise the attorney's liabilities on Dong's. And the allegation that an attorney conspired with their client is surpluses, requisite. God, okay. You guys know what it means. And a malicious prosecution action. Disposition. Dong's appeal for the denial of the anti-SLAPP motion is not dismissed and the judgment is otherwise affirmed. All right. It's all right. It's all right. I thought you were making fun of me. I thought this was some type of OSA fucking thing. Just make fun of DOA's speech impediment. I thought you weren't being clear with the ADA. It's okay. I won't hold it against you. And this is just me joking. Okay. I don't believe you're, well, I'm 98% sure. This is just my opinion that you're not OSA. I still put 2%. You might be playing the long game. You and pseudonym. Pseudonym is more like 0.002%. But all right, so I have to get a bunch of things tomorrow. Okay, so cost report 570, 527. Okay, you attacked it. All right, so let's help me write an email to counsel about Wong and Dong for our meet and confer tomorrow. Malicious prosecution, SLAPPback, Wong versus Dong. Counsel, ahead of our meet and confer, I want to identify a recent published California decision that I believe is directly relevant to the issues raised concerning my malicious prosecution cause of action against Francois. Wong versus Dong, the Court of Appeals addressed whether a subsequent malicious prosecution action qualified as a SLAPPback under Code of Civil Procedure, Section 425.18. The court held that it did. Notably, the underlying cross-complaint in Wong had been voluntarily dismissed while the anti-SLAPP motion was pending. The trial court later determined in connection with attorney fees that the anti-SLAPP motion would have been granted. Court of Appeals held the resulting malicious prosecution action nevertheless satisfied the statutory definition of a SLAPPback. Oh, I just assume everyone's OSA. Love those glasses. If people in the chat knew who the fuck you were, they might think you're OSA. They might say you're a shit stirrer. I don't think so, but I know who you are. No, stay hidden, girl. Stay hidden. Don't let the psychos find you. They're everywhere. My circumstances appeared at least procedurally stronger on this particular issue. In Koster versus Hochstetter, I did not merely obtain a voluntary dismissal while an anti-SLAPP motion remained pending. My special motion to strike under CCP 425.16 was actually granted, and the court subsequently awarded attorney fees under 425.16C1. I also believe Sukup versus Law Office of Herbert Half is significant. Sukup recognizes the SLAPPback framework and addresses a malicious prosecution action following successful anti-SLAPP proceedings, while separately analyzing the traditional elements of favorable determination, lack of probable cause, and malice. I understand that prevailing on an anti-SLAPP motion does not stand alone automatically establish every element of malicious prosecution. My point is narrow. The procedural history of Koster proceedings appears directly relevant to whether my malicious prosecution cause of action constitutes a SLAPPback under CCP 425.18, and Wong is recent published authority that should be considered before the parties take final positions regarding that claim. I would therefore like to discuss Wong and their application to the malicious prosecution cause of action during tomorrow's meeting for providing the authority in advance so counsel has an opportunity to review it so we could have a productive discussion tomorrow. Also, let's put in the talk about there being nothing about me and about other protesters And let's okay, also let's put in the talk about there being nothing about me and about other protesters. So the probable cause element of it. Also, I believe I'm going to amend the complaint. I'm going to amend the complaint. I'm going to amend the complaint as new evidence of body cam footage from my arrest on 5/25/24 has what I believe are some malicious elements that will need to be added. I'll address it in a second, Juju. That's actually, I put that in my Title 42 for the San Luis Obispo and the city of Los Angeles for the Monell claim, or for the elements of Monell. Some malicious elements that we need to be added. One, the police officer telling Francois that my case would help her case, her talking about my van being towed, and also the use of music. Hotel California specifically, being used to stop us from live streaming and protesting, which was effective for some of the protesters, although Francois claimed in the restraining order that I was there for monetization. That was there for monetization from clicks and views. I actually was not monetized, and and if I had 1 million views or 2, I got paid nothing at all for any views. So basically, there lacks. So basically, there. I can't believe it was 2 years ago you were arrested. Yeah. So basically, there is no. So basically, there was no probable cause. I got the dick pics on there. It's in the lawsuit, actually. It's part of the malicious. It's part of the talking. Yes, I would add those points, but I would not write therefore there was no probable cause to establish fact. The safe struggle for malicious and newly obtained evidence combined with the evidentiary record from the anti-SLAPP supports your contention that Coster lacked probable cause and may bear on malice. Sokol treats probable cause and malice as separate elements, so we want counsel to focus on what Coster actually knew and believed when she initiated and continued the proceeding. Okay, let's see what it wrote now. Don Henley, the Eagles would not be pleased. Heavily copyrighted. Well, also there, so there was actually someone sent me. We had gone to the meeting where we were like, it was about the zoning for the fresco dining, and that whatever permit or whatever they had for that specifically said that they weren't to be playing music, amplified music outside. So they weren't legally allowed to do that anyways per their permits. Counsel, ahead of our meeting conferred tomorrow, I wanted to identify a recently published California decision and several factual issues that I believe materially affect the proposed challenge to my malicious prosecution cause of action against Francois Coster. In Wong versus Dong, the Court of Appeals addressed whether a subsequent malicious prosecution action qualified as a slapback under Code of Civil Procedures, Section 425.18. Okay. Trial court subsequently determined connection with attorney fees that the anti-SLAPP motion would have been granted. Yeah, it's an interesting little point. My circumstances appear at least procedurally stronger on that particular issue. In Coster versus Hoxter, my special motion to strike under CCP was granted, and the court subsequently awarded attorney fees under 425. Sukup versus law offices is also significant. Sukup recognized the slapback framework and addresses malicious prosecution following successful anti-SLAPP proceedings, while separately analyzing favorable termination, probable cause, and malice. I understand the prevailing anti-SLAPP motion does not stand alone automatically establish lack of probable cause or malice. However, I believe the underlying evidentiary record and newly obtained evidence raises substantial issues concerning both elements. One issue I tend to address is the extent to which Coster's restraining order presentation relied upon alleged conduct of other protesters and third parties rather than conduct attributed to me. This distinction was expressly raised in my evidentiary objections in the underlying proceedings, where numerous paragraphs were challenged because they concerned third-party conduct rather than conduct by me. There are also factual allegations Coster made concerning me that I contend were false, including allegations concerning stalking, following her, gang activity, violence, tear gassing, and my criminal history. These matters are relevant to what facts Coster actually possessed when she initiated and connected the restraining order proceeding, and therefore to the probable cause and malice analysis. Additionally, I received obtained body-worn camera footage from my May 25th of 2024 arrest that I believe contains additional evidence material to the malicious prosecutorial claim. I'm presently reviewing that evidence, anticipate seeking leave to amend the complaint as appropriate. Among other things, the footage apparently records, 1, an officer telling Coster that my arrest would help her restraining order case. 2, discussion involving Coster concerning having my van towed, and discussion concerning the use of copyrighted music, specifically Hotel California, in connection with preventing or interfering with protesters' live streaming. I believe the latter evidence is particularly relevant because Coster's restraining order allegations characterize my activities as being motivated by monetization, clicks, and views. I dispute the factual premise. At the relevant time, my live streaming activity was not monetized, and I received no revenue from the views at issue. Evidence concerning deliberate use of copyrighted music to interfere with live streaming may therefore also bear on the nature and purpose of the underlying dispute and Coster's characterization of my activities. I'm not suggesting that these facts should be conclusively adjudicated through the meet and confer process. Rather, they demonstrate why I do not believe the malicious prosecution cause of action can properly be evaluated merely by characterizing the underlying matters as an unsuccessful civil harassment petition. The relevant inquiry includes what Coster actually knew, what information she possessed concerning my individual conduct as distinguished from the conduct of other protesters, whether there was an objectively reasonable basis for the claim she pursued against me, and whether the proceedings were initiated or continued with malice. Given the actual anti-SLAPP disposition, the subsequent attorney fee award, the recently published decision in Wong, and additional evidence that has now become available, I believe that amendment rather than dismissal is appropriate to the extent counsel believes additional factual allegations are necessary. I would like to discuss these authorities. Okay. Your conduct versus other this is just not rhetoric. Your attorney's June 24th evidentiary objections repeatedly argued that Coster was relying on conduct by third parties. This helps frame the probable cause question about what evidence actually connected you individually to the supposedly unlawful conduct. Okay. Also, let's add in a section about discovery and how we're going to focus on the 20 most important items. Let's add in language. Be careful what Osa's trying to get you involved in, chat. Be careful. Let's add in language. Let's add in language that What else do we want to add? Let's add in language that as the anti-SLAPP alleged of others, I also have alleged others, but not as a cause of action, but as a factual background of why security was needed and why that knowledge helps with the elements of my claims of negligent security. You're a logger? Goddamn it, DOA fucker. Now I'm cussing. Goddamn right. The decision you make is important. Costers anti-SLAPP opposition allegedly used third-party contact as evidence against you personally, whereas your complaint can describe a tax incident involving other factual background relevant to law of well notice. Love you guys. We can get DOA to be our lawyer. I don't want to be a lawyer. This shit sucks, yo. I don't want to do this shit. This is boring. Like, I got so much to do. I'm going to go to LA tomorrow, but I got a lot to do. I got shit to do in Aaron's case. I got shit to do. Well, this I'm working on right now. I'm going to see what I could hash out with him tomorrow. And then I'll probably be amending this. SLAPP. Okay, for the Scientology stuff, the 16 things, I'm putting that in with the, I think I'm going to allege a conspiracy in the SLO thing. I'm not sure. I got there's like a couple new defendants I've added to the SLO, and yeah, it's actually coming along really good. I just want to finish this and I'll go over the thing for a little bit here. I have a meet. I want to advise recently newly obtained evidence several discovery issues that I believe materially affect the proposed challenges to my complaint. Okay, we got that. Probable cause, my conduct versus conduct of others. One issue I tend to address is the extent to which costers restrain or position relied upon alleged conduct of the statement was supposed to be raised in evidentiary objections. Newly obtained May 25th. Okay, that covers all that. I read all that. I'm not asking counsel to adjudicate these factual disputes during the meet and greet. My point is that the malicious prosecution claim should not be evaluated simply as an unsuccessful okay. Other incidents as factual background, negligence, security. I also want to clarify an issue concerning the allegation involving attacks, confrontations, threats, police response, and other incidents involving recognize the distinction between alleging injury to another person as though I constituted my own cause of action and alleging those of events as factual background relevant to my own claims. I'm not asserting causes of action for personal injuries suffered by other protesters or third parties. Rather, those incidents are alleged as factual background because they may bear upon La Poubelle and Coster's actual or constructive knowledge of reoccurring confrontations, violence, dangerous conditions, and security problems that are immediately surrounding the premise before I sustain my own alleged injuries. That distinction is also relevant to the prior anti-SLAPP proceeding. There, I objected Coster attempting to attribute the conduct of third parties to me as evidence that I personally engaged in harassment or unlawful conduct. Here, I'm not attempting to attribute other person's injuries to myself. I'm identifying prior incidents as evidence potentially relevant to notice, foreseeability, knowledge, and the adequacy of security measures and whether reasonable measures were taken in response to known conditions. The principal personal injury event underlying my negligent security allegation remains the April 17, 2024 incident, which I alleged Gage and grabbed and threw my phone and pushed me in the table, and Ethan struck me in the face and spat upon me, resulting in black eye, bruising, and property damage. The earlier incidents provide the factual chronology relevant to what defendants allegedly knew or should have known before April 17th. They are not pleaded as independent causes of action belonging to me merely because another person was involved in injury. Discovery, narrowing the initial dispute. I also want tomorrow's discussion to address the outstanding discovery responses Although my amended request for production contains substantially more than 20 requests in an effort to meaningfully meet and confer and avoid unnecessary motion practice, I intend initially to focus our discovery discussion on approximately 20 of the most important requests. Those priority requests will focus primarily on the April 17th attack, surveillance video, photographs, and other recordings, incident reports, security reports, and witness statements, security personnel and persons working on April 7th, preservation, deletion, communications, and evidence exchange with LAPD, cautious statements. This is intended good faith narrowing. Okay. Okay. One thing I want to do with the 20 discovery things is to get info on the other attacks and how security handled them, and especially the ones where the attackers re-entered into the restaurant. Also make note that every discovery request was a not can material, what's it called when everyone's the same one? It's not can material. It is a can response. No, boilerplate response to every discovery request. Okay. Yes, I would change the description because that gives the 20 requests a much cleaner purpose. Okay. This matters. I believe there's a significant problem with the manner in which the response was answered. The inserts of the same boilerplate set of objection response to each individual that rather than meaningfully addressing the subject matter that requests concerning material of different subjects, surveillance recordings, nevertheless, in an effort to meaningfully meet, I intend to initially to focus on approximately 20 of the most important requests for production rather than attempting to address every deficient response at once. However, an equally important component of the approximately 20 requests will concern the earlier attacks that confirmation current at or immediately outside La Poubelle before April 17th. I am seeking for not to recover damages for injuries sustained by other persons, but to determine, among other things. Okay. Write me one finished letter now, and I'll email it to him. Counsel ahead of the meeting current on the internal authorities, malicious prosecution, probable cause, newly obtained evidence, prior attacks and other protests. I'm not certain cause of action from injury, discovering, blah blah blah. God damn, that's a lot. Okay, copy. All right, I'm gonna send this email. Fucking, I love ChatGPT, man. I could just kind of think about it and like put it into a. Yeah, it's so fucking amazing, truthfully. All right, I got this already filed away. I've been so on top of my emails, trying to at least for the court stuff. La Poubelle lawsuit. Okay, got a folder there. I want to send the Shapiro. Copy email address. Boom, 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 boom. Paste. Subject. Notes. So you don't have to talk to me so much. Okay. I gotta copy that again. I fucking love chat. I mean, like, I love it because it's like it remembers everything, all the dates and all the names, and so it just makes everything like. That's where I really struggle is like remembering the names and all like some of the details. Tell you what, though, my details, the timing of everything is really starting to come together real nice. Just in like how I retain, like what information I'm retaining, and like when all the dates happen. Because like 6 months ago, I was just not there anymore. I was not there. But I love this, you know, like I don't mind doing the work because every time I do something different, like I love, you know, him saying that I don't have the prosecution or like that I don't have what it was. And so I put it in the chat GPT and then all of a sudden I'm learning about Wong and Dong and the anti-SLAPP. And so that's like, yeah, that's just really cool. Just in terms of my overall knowledge of how to sue, when to sue, how, you know, it's so important to know. Okay, counsel ahead of our meeting conferred tomorrow. I want to identify several authorities, newly obtained evidence, malicious prosecution, SLAPPback, Wong, Dong. Believe law. Okay, I understand the probable cause, allegations against me versus other conduct of other protesters. Newly obtained May 25th, 24 body cam evidence. Prior attacks and other protesters' factual background supporting negligent security. Security response and re-entry following prior attacks. The re-entry issue is particularly important if the evidence establishes that management security knew that person had just participated in an attack or violent confrontation, nevertheless permitted that person to enter or return to the premises. I believe those facts may be relevant to the negligent security issues of notice, foreseeability, security practices, and reasonableness of the response to known conditions. Good faith narrowing of approximately 20 priority requests. I don't need to do 20. I'll do 40. I'll give them. Okay, what do I want? Defendant's proposed pleading challenges and what issues may be resolved through amendment. The application of Wong. Newly obtained evidence, petition bearing a probable cause and malice. Clarification of the purpose of the prior incident allegations. Substantial supplemental response to protection concerning approximately 20 priority discovery requests. Okay. Send. All right. I got that done. Okay. I gotta send an email real quick. I'll put on a little. What can I put on here?
Technically, turning tricks is working.
Okay, we're gonna do a little pussy song. We just have to have pussy song every time. Is that it there? Right there.
Down in the woods today, you better go in disguise. For every bear that ever there was will gather there for certain, because today's the day.
Do you have good karma?
I'm service.
Yeah. I have to admit, I love your pussy song.
That's so disgusting.
You don't like it?
Why do you like to talk about sex so much?
It's your song. It's your song.
Not really. That was a fake song made by AI intelligence.
It was made by AI. Oh damn! I would have rocked that one. I like that one.
Can you just chill out today and walk
No,
away?
I can't chill out, man. Glory be. Glory be. Why are you guys not standing up for Taylor?
We don't know who he is.
You guys don't know who fucking Taylor is? There's Shoot Mama. She loves her cocaine fingers. Hey, where's Brian Brassi, Shoot Mama? Huh? Where's Brian Brassi, huh, Shoot Mama? Oh, where's those dirty cocaine fingers?
Pacific, African, yes, South Pacific Islander, South American, Middle Eastern, Eskimo, Icelandic. Free to be you and me, what happened to that? Free at last, free at last, I wanna say free at last to you, Cardi B, to you, Doja Cat, I salute you, to you, Candace Owen, we gotta be free at last, free at last, this is about, do you want your personal freedom of expression? My type white ass pussy, I need your big thick cock, you want my pussy? My type white ass pussy, give me whatever you got, my pussy. My type white ass pussy, I need your big thick cock, you want my pussy. My type white ass pussy, give me whatever you got. Free at last to express ourselves, free at last, this is our freedom song, free the pussy, free at last, take your sexuality back. Do you wanna be free or you wanna be oppressed? You wanna be free or you wanna be oppressed? I want all y'all to wake up, I got woke, wake up, let's stand together, unite.
Okay, cool. Yeah, like I said, I really, who said that? I'm gonna get the person who said it first. Squirrel Vaz, didn't you just do this the other day? Asking where somebody was? Squirrel Vaz, wasn't that you yesterday or the other day? Asking where someone was it yesterday or 2 days ago? Or was that somebody else? Yeah, I'm gonna be putting in a rule that just no asking. Yes, stop asking where the fuck people are. Like, because it just all that like it just makes the shit fucking weird. Like, yeah. You're canceled for today. That was Squirrel Vaz yesterday, wasn't it? Yeah, see, like that shit just stirs up fucking like, where's MD Media? Where's this person? Where's that person? Where's yeah, goddamn. And then people start giving hearts and like, yeah, it just makes everything fucking weird. Yes, it was. All right. I could hide that. Oh, that's kind of cool. Notes. Let people live your damn. Yeah, like just who the fuck cares where they're at? There's a meteor shower, new moon. Well, I'm in LA. You can't see shit for anything. People. Notes. Widgets. Style. Media. Comments. That's why. That was why I said. Yeah, see, like people just want to be like, oh, we're like people like, and that's what it makes it weird, because it's like it makes people feel that they have to come to the stream, or that if they're not around, like, it just makes all that fucking weird. It starts to make problems where there's not problems, and there shouldn't be any problems. And so I'm a few thousand years. And like Sandra could never come back, and Sandra could never talk to me again ever, which I've talked to her, and she has done so much for me. She came to so many fucking court hearings. Like, she came to so many, like, she's not a content creator. She's made no money. She put all of her own money into this. She did all the stickers for Laura. She did all the shit. Laura shit on her. Ashley shit on her. They were all just pieces of shit. So Sandra is she helped with the occupation. She cleaned up. She did all the work at the occupation. She caught all the shit from Becky. And she has her own health. She has her own health problems. And my friendship is not based on her coming to my chat. She could not fucking be here for the next 6 months. Yeah. And so, but like, for other people, I see the tactic of that. And like, some people, like Holly, always ask these questions because she's concerned about people. And that's why I think sometimes Holly's OSA. Right. And so, yeah. I'm really, I don't want anyone talking about asking where anybody the fuck is. I also feel really weird when people are all fucking like just yeah, they're not obligations. Yeah. So Sandra can never come ever again, and she's done more than most people have done for me. Specifically just helping with a lot of stuff, and specifically the court stuff. She came to, there was 27, I think we're at 26 or 27 court hearings, which is interesting little nugget of information that photo guy had. So she came to at least 20 of them. So 20 days she came, she drove, she got ready for court, woke up early, sat in court, like, she's done her fucking part. Like, she's was a fundamental part to all this. So, yeah. And I also, like, sometimes people like say, "Oh, I'm sorry, I haven't been in chat, or I don't watch," or like, I don't expect anyone to watch. Like, my friendships aren't based on people being in my chat at all. And, you know, a lot of people were watching before, and then they got tired of some of the drama. And there's a bunch of reasons. People have other shit going on. It's not entertaining enough. There's too entertaining. Like, it's just an assortment of reasons. So yeah, so I'm going to be like really pushing that. The people were trying to fucking push the shit with MD Media, and I actually talked to MD Media, and I was like, well, why the fuck haven't you come to any court hearings? You know, what the fuck? Come to some court hearings. It'd be nice to have some fucking support. So I talked to him, but people are like, oh, where's MD Media? They're like trying to fucking push and make like issues where there is no issues. Or there might be an issue, and that's okay to have fucking issues. Like, if you have like friendships and you have like things with, you know, there's always issues with friends. That's fucking normal. I wish I had like friendships that there weren't ever any issues ever. Holly, I don't need to make fucking rules. The pin to the fucking top. I'm just gonna yell at fuckers and call them Osa if they don't fucking do it. Okay, it's really fucking simple. Don't be no chimosa. Okay, no chimosa. Don't worry about what everyone's doing. And anyone watching could really use fucking people coming to court. There's been a lot of people coming. Griselda comes all the fucking time. You know, people coming to court. People coming to court is so fucking important. All right, this is not a goddamn thing if you like Matt or you don't fucking like Matt. Jesus fucking Christ. See, this is why you don't fucking bring up the shit. It just fucking, it just becomes stupid. It becomes fucking really stupid. So, I'm just going to end this because it's fucking dumb. So thank you for being here. I'm going to rule with an iron motherfucking fist. I'm going to yell at chat. Don't encourage these. Okay, there's Butterfly. Ban user and delete comments. There you go. I'm just going to do that. Yeah, it takes over chat. It's fucking stupid. Love those glasses. You're getting timed out. Put user in timeout. You're timed out. Oh, you were banned completely. You shouldn't have been banned. It just tried to time you out. Why did it ban you completely, though? Was banned in the comments. Yeah, I didn't mean to ban you. And I can't undo it. I'll get you unbanned. If you're unbanned, you might just be banned on one of the channels, whatever channel you're on. I'll get you unbanned, though, if it did ban it. I hit timeout. It should have timed you out for like a minute or two. Yeah. I'm not there because of distance or money. Well, there's a fucking ton of reasons, and like to bring it up and like it just fucking starts causing fucking shit. It just is stupid. So I'm just gonna rule with an iron fist. No talk about other streamers or non-streamers. Right? That's the rule. That's a lot of rules and a lot of different things. And I didn't do that because I promoted everybody, but I don't want to promote anybody anymore. Promote yourself by fucking being awesome. That's how you promote yourself. Be friendly with people. Oh, I know. See, I'm not trying to say I don't have support. Holy fuck. It's not. Jesus fuck. All right. I'm done. I've had enough. Good night. Love you guys. Bye.